arbitrationagreements.org. Welcome, alternative dispute resolution enthusiasts. Today we delve into the basics of an arbitration clause, a key feature in many terms and conditions documents. But before we begin, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. So, what exactly is an arbitration clause? It's an agreement within a contract that specifies that any disputes arising between the parties will be resolved through arbitration rather than litigation. Interesting fact for you, our Cent report indicated that over 90% of parties surveyed felt their arbitration experience met or exceeded expectations. With such positive feedback, it's no wonder these clauses are popular. Arbitration clauses can vary widely, but they often include several critical components. Firstly, they define the scope of disputes to be arbitrated. This could be all disputes or only specific types depending on the language used. Secondly, they describe the process of selecting the arbitrator or arbitrators. Generally, there may be 1 or 3 arbitrators, depending on the complexity of the dispute. Third, clauses define the location of the arbitration or the seat. This is critical as the arbitration laws of the seat will usually apply. Then they might specify the governing rules for the arbitration. For instance, it could be the rules of an association like our own. The clauses also address confidentiality, a selling point for arbitration. This provides privacy, which is not available in most court cases. One last thing to note about arbitration clauses is that they are often take it or leave it for consumers. A 2020 survey by the Consumer Financial Protection Bureau found that less than 2% of consumers actually read these clauses. A reminder to always read the fine print. In fact, mandatory arbitration clauses require parties to arbitrate any disputes, essentially waiving the right to a trial. Lastly, it's worth knowing that not all arbitration clauses are enforceable. They must be fair and not overly favor one party. If a court finds that an arbitration clause is unconscionable, it can be voided. To learn more about arbitration clauses or have our experts draft a clause on behalf of you or your business, head on over to arbitrationagreements.org. That's where you can buy the service or program you need right away and begin the dispute resolution process quicker. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Countless companies and individuals utilize our services to handle claims in a controlled manner through cost-effective solutions. If you're interested in doing that as a business, we are standing by. Also, successful companies depend on arbitration to save money. You're paying one service per case instead of experiencing the uncontrolled expenses of a standard lawsuit. That's the key reason why arbitration is so popular. Also, what do you think about arbitration clauses? Does the concept make sense to you? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.